the topic today. Our primary trainer is Trina Kokalis, and she is a lawyer and former housing counselor with Long Island Housing Services in the foreclosure prevention program. Trina has been working side by side in the development of this training today, also with Stephen Sharp. Some of you may know who he is. He is frankly, a national leader on FHA loans and dealing with these types of issues that many of us are encountering across this state, and he's really blazing quite the trail from his position in Ohio with Legal Aid Society of Southwest Ohio. So Trina is really offering the basics of what we should be looking at when you have an FHA loan. There are requirements that they have to follow. Sometimes they don't, and Trina is going to offer some tips and tricks on how to identify those things and make your cases more workable for you. And also, we have a training coming up on April 20th where Steve is actually going to be presenting on those DASP loan sales. So these two trainings really build off of each other. So Steve has agreed to actually be really the moderator today, and be moderating and monitoring, the questions that come in. So this is really the Stephen and Trina show, and I'm so grateful for the two of them to present to today. So I leave it to their capable hands. Trina?
Hi, thank you, Becky. I'm so glad to be asked to present this particular topic today because, in confession, I find FHA loans very interesting. And it's my hope that after today, you'll look at them a little differently. And also as a new opportunity to apply your skills as an attorney or as a housing counselor. And that's because FHA loans and, oops, sorry, I'm trying to forward my slide here. FHA loans and FHA servicing is highly regulated. It includes several important protections for FHA borrowers in default. FHA mortgagees and their servicers must follow standards and procedures established by HUD, and noncompliance of these important protections can be used as a defense to foreclosure. So before we dive in, again, this is a basics course, and I just want to make sure everyone's up to speed on a few terms that you'll be seeing. So FHA loans, these are loans that are made by private lenders. They're insured against the possibility of default by the Federal Housing Administration. So if the borrower doesn't repay the loan, FHA pays the lender, and they pay the remaining principal plus any allowable fees and costs. These are very safe loans for lenders to give. The mortgagor is the borrower, the one who gave them the mortgage to get the loan, and the mortgagee is the party who holds the mortgage to secure the loan. The servicer, that's an agent of the mortgagee and is held to the same servicing standards as the mortgagee, and that's important. The lender, I'm just going to use that's a catch-all term that I will use for mortgagee and its servicers, and I do that simply because it fits better on the slides. So keep that in mind, that's the mortgagee and its servicers who's held to the same standards as the mortgagee. So why is FHA servicing highly regulated? And why is noncompliance a potential defense for foreclosure? And basically it's because HUD said so when it created the FHA program. The legislative goals are codified in federal law, and they provide important context for the special FHA servicing requirements. The goal of FHA is to make loans to low and middle income families, quote, to assist in providing a decent home and suitable living environment for every American family. So HUD understands that these borrowers who would not qualify for a conventional mortgage loan are more vulnerable to default. And that's why it specified requirements for early default intervention and loss mitigation. HUD also restricted the lender from being able to start foreclosure until all the specified servicing requirements have been met. So FHA history and its policy is important to keep in mind. It not only informs the basis for these servicing requirements, but it makes them non-trivial. Okay, so as said, the primary sources of authority for the FHA servicing requirements are encoded in federal law, and mainly that's the National Housing Act and the Code of Federal Regulations. We also look to the note and mortgage, which are enforceable as private contract. And of course, we looked at case law to see how the courts have interpreted statutory and contract language. And we'll talk about the Teed case later because it's the primary judicial authority for New York. So secondary sources of authority are available through the HUD portal website. These are the infamous HUD handbooks that we all know and love. So that's where the agency publishes its rules and regulations. And then the mortgagee letters are where the agency provides clarity or changes to the handbook. So Stephen, did you want to explain some of the form note changes and talk about the HUD National Servicing Center?
Sure, that sounds like great. Hi, everyone. Steve Sharp again from Legal Aid Society of Southwest Ohio. Really glad and honored to be on the call with you all. And I've talked to a lot of really great work. So one thing that was really important that Trina mentioned is that what's so great about FHA cases, not only does it serve the clients that we should be serving with low and moderate incomes, but there's great leverage and great issues to raise for legal defenses. Not only the regulations, but in the contract also has historically, and for the most part, for the loans you will see, directly incorporates the regulations into the terms of both the note and the mortgage. And that's really important because it turns it into something between the homeowner and the borrower, or sorry, the borrower and the lender, and not just something even could be claimed between just HUD and the lender. And it's three important points on that. One, it's important to notice, and I think Trina's primary sources and secondary sources really spell this out, that it's the regulations that are what has been incorporated into the contract. So we really need to have a laser focus in on those regulations, which we'll talk about, which Trina's going to go through in the session. And also, it's regulations plural, and that's really important. It's not just the face-to-face meeting, which many of us know and love so very well. There are other regulations that we can use to tell a full story, to take good cases and really have a compelling story. So after all that positivity, I have some negative news to share with all of you, but I think some of you know this, that unfortunately, fairly recently, HUD has removed the really important language in the form note at paragraph 6 and the form mortgage at paragraph 9, which has this important language, the regulations into the contract. So what I will say about that is they did that in a way that we think many people around the country are working on this issue, including folks in New York, does not hold up to scrutiny under the APA. And there are many of us right now working very hard to get this language back in the contract. So I am not giving up on this at all, nor should any of you. But I wanted to highlight it because you may see FHA loans without this language, so it's very important as a practical matter to check. But also, if you are seeing contracts without the form note, if you actually run across them, please let me know. My contact information is at the end. My cell phone number, this is how important I think this is area code 513-331-1074. You can ask me any question about FHA, but that is how important I think the contract language is. So please let me know if you see it, and please understand that this is not over by any stretch of the imagination at all. So I think that's important in terms of the primary source and secondary source. The one other thing I wanted to mention quickly is that for those of you who, so Trina has this great note saying servicer investor internal rules and procedures that are in conflict have no force, and I think that's very important. I think though that what you're going to see is that go figure that lenders may not always follow the rules. So one option that I want you to be aware of is that when you see issues, you can elevate or escalate cases to the National Servicing Center, which you can just Google, but and it's pretty easy to get contact information, which is really a HUD complaint line for dealing with issues. Specifically, I think best when we're talking about less about the regulation violations and more about when you're trying to work out a loan modification or other deal for your client. And what I will tell you is it's important to escalate problems you're seeing to HUD's NSC, National Servicing Center, but don't expect that this is going to be a fix-it for everything. I'm not going to go into detail about what is especially good for the NSC and what doesn't work so much, but I think those of you who work with the NSC kind of have that take. But I think it's very important to escalate cases, and it's especially important when the lender is saying that HUD is causing the lender to do something, and that's just not what the rules say. I think those cases are really can be worked out well. So again, if you have issues with the NSC or want to talk to me about how that goes, feel free to give me a call. So I think with that we can pass back to Trina and also kind of get into the nuts and bolts of the specific regulations and other law.
Great, thanks. Okay. Whoops, where's my? Okay, so here we are. The actual requirements. The statutory language of the National Housing Act grants both the authority and an obligation that's in loss mitigation. So now watch how these are going to fit together in the next few slides. HUD expressly states its intent to prohibit the lender from commencing foreclosure or from acquiring title until the servicing requirements have been met. So they can't do anything until the servicing requirements are met. What are those servicing requirements? That the mortgagee must have a face-to-face interview with the mortgagor or make a reasonable effort to arrange such a meeting before 3 full monthly installments due on the mortgage are unpaid. And so some of us have never even heard of this, so I'll just pause while you can stop laughing. But if it seems crazy, HUD was completely serious about these requirements because if you remember, FHA loans are completely insured against loss. And HUD expects that a fair number of their borrowers are going to encounter financial hardship that might cause them to struggle with the payment. So HUD wants to avoid the loss, and they require the lender to follow the loss mitigation scheme to, try to avoid the loss that they have to pay out. So this includes making reasonable effort to try to reach the borrower and resolve the delinquency. Okay. So what counts as a reasonable effort to arrange? That would be, at minimum, sending 1 certified letter and making 1 trip out to the borrower at his property. And we'll go over some exceptions in a minute to where the lender would be exempt from this face-to-face requirement. But first, we wanted to ask a question for the audience. We'd like to hear from you. Have any of your FHA clients either attended a face-to-face meeting or received a certified letter and a visit to arrange the face-to-face meeting? So let me do the poll. Please, can you see the poll?
I can see the poll, yeah.
Great. Oops. All right, so we're trying to get a sense whether this is happening anywhere at all in New York. My clients on Long Island, and I have a lot of FHA clients. I think maybe half my cases I wouldn't be surprised to find out are FHA. While we're waiting for the poll to close, Stephen, are there any questions in the chat box that you've seen?
Yeah, there's at least one. I referenced to, I said the word APA, and okay. By that I meant in discussing the possible issues with HUD's removal of the form note mortgage, I used an acronym which I should not, the Administrative Procedures Act, which governs when agencies can take action. I think okay. There are issues with, so that answers the question. Sorry for using that. I think that's the main other question. Also, just to confirm that there will be a training on distressed asset stabilization program coming in April, and I will be the presenter for that. So that's focused on an issue that will come up. So for those of you who are thinking about that, there will be a training on that coming up.
Great. Okay, so I think we got some votes down. I think I'm going to close the poll out. And am I back on? Can you see my screen again? Okay. All right, great. Okay, exceptions to the face-to-face meeting. It's not required if the mortgager does not reside in the property, or the property is not within 200 miles of the mortgagee, its servicers, or a branch office of either, or the mortgagor clearly indicated he will not cooperate, or a repayment plan is entered into and it's current, or a reasonable effort has to arrange the meeting is not successful.
Hey, Trina.
Yes?
It's interesting, these things that come to light, right? So a lot of folks they've never heard of the face-to-face. Can you explain a little bit? It's not completely self-explanatory, the title of it, but can you explain exactly what that is for folks that have never heard of it before or have never seen it?
Well, sure. It's a requirement that the mortgagee or its servicer send out a person who is knowledgeable and able to resolve, empowered, authorized, I guess is the right word, to resolve the borrower's delinquency in the event that they're able to create a workout. And they were to go to the person's house and arrange to meet with them face to face.
And it's really interesting. Yeah, I think it's interesting. The poll results came back as, not surprisingly, about 94% of you said that you have not seen this.
And I think, Stephen, you said you're seeing it more in Ohio, but you're also litigating more in Ohio.
Yes, and I think that's a really good, important segue, and I also can answer some questions that have come in on that as well. So I think in Ohio, where we don't have the settlement conference mandatory, we as legal aid advocates have been forced to litigate the issue of the face-to-face meeting and also the other FHA regulations much more. And we've had success, and with success becomes more lender scrutiny. So I think as you all start using this as leverage in your cases, and if you do have to start litigating, you are going to see lender efforts of compliance. And the question then will become, are they really doing something to actually satisfy the regulation, or is it something that isn't even close? Or like it but is not actually. So I think, so someone asked a question about what if a lender sends a company to do the face-to-face inspection? And I think that was a very well-titled question, because what we're seeing in Ohio are sending out third-party people to do various aspects of the face-to-face meeting. And as Trina noted, there's both a duty to make an effort to arrange it and a duty to actually have it. And so what I would are the handbooks that were posted in the secondary sources. And there are two, because the handbook 4330.1 is in effect now, but will soon be out of effect and will be replaced by 4000.1, which comes online in March of this year, the servicing section, and will then provide the guidance on a face-to-face meeting. But first, we should always start from the reg and understand that the reg is the main piece of the law, and then look at the handbooks as support. So I think the answer to the question about what if they send other people out, I think you need to look at the handbook and see what part of the handbook does it fall into. Because actually in the new handbook there's a slight change that it seems to allow, and I haven't seen this in practice yet. Maybe the inspection, a third party would be fine for the arranging piece, arranging the face-to-face meeting, but the handbook does not change the fact that the person, according to HUD's handbook, who is going to do an actual face-to-face meeting needs to have some authority. Okay, and so what happens in Ohio is some of these issues are going to come up in discovery. You know, who did you send out? What authority, if it is for the person with a face-to-face meeting, did they have? I would say that that's sort of where this goes once you have success getting this established and you start litigating this more and the banks start trying to comply. Because what I will tell you is that poll result will be much different in Ohio than it would be in New York, where we're going to see a lot more attempts to comply. I would say yes, I would answer that question, yes. So I think to answer another question about whether people, whether lawyers should be asking about the face-to-face meeting, if it's happening, yes. But I think you want to get into some of the details and really cover with your client, what letters they received, what did someone come out. It's also an issue that you're going to want to explore to some extent in discovery. And then finally, so I think that answers that question as well. Finally asked, does the handbook articulate the intent of the face-to-face meeting? That's a great question too. And what I would say is the former handbook 4330.1 I think had some more depth on that. But even the new handbook, when it talks about the fact that the person doing the face-to-face meeting should have authority, that I believe tells you what the true meaning of the face-to-face meeting. So I think that's important. And so finally, and then I'm going to pass it back on. And there's a lot of questions which are great. Some of this I can address later, but I think we have limited time. For housing counselors, I think they should ask that question as well. At least to me, as something in Ohio, I often get cases from housing counselors. I think that's a good thing to know and to talk about to see if that's happening, because all of this is supposed to happen fairly early in the process, as you can see from the time frame. So why don't we throw it back to Trina to kind of go through some more of it, but you're asking some really sharp and important questions.
Thank you. And Stephen, that was a perfect segue back to where we are. So as you can see, before 4 full payments are due and unpaid, the mortgagee shall evaluate all of the loss mitigation techniques provided to determine which is appropriate, and then take appropriate loss mitigation action. As you can see, this requirement is predicated on the servicer having had met with the borrower before 3 monthly payments were due. I mean, in reality, what we see, we know the homeowners would be lucky to get their single point of contact on the phone before 4 months. But this is the crux of loss mitigation scheme. Attempt to fix the borrower, meet with the borrower early, before the 3rd month of default, in order to try to fix it, and then run them through options before the 4th month of default. So the last main piece of the FHA notice requirement or the properties owned by a corporation or partnership. Other than that, these are the main FHA notice requirements that come together to form. See now how we can put them to use for our clients. Okay, so let's see. Oh, before we dive into the defensive theories, which have been really successful in the courts, we want to be clear on how not to plead. The statute provides that there's no private right of action for borrowers. The important takeaway here is that homeowners cannot merely complain that the lender violated the statute and the homeowner was harmed, but the homeowner can still use that claim that the lender violated the statute. You just need to use it together with the other theories that we're going to review in order to be successful, and you'll need to reframe it and connect the dots a little differently, and we're going to go over it, and then Stephen's going to go over it even more. It's just one of these arguments. You have to keep in mind it's a shield, not a sword. So, okay. So The defensive theories. So there's several defensive theories to use when we're crafting your arguments. They've all succeeded, and there's a lot of authority in persuading courts to hold that noncompliance with loss mitigation requirements is grounds to stop foreclosure. Let's see. Statutory violation. The regulations, they impose a condition precedent to foreclosure which is not satisfied. So in other words, the statutes, they only authorize foreclosure by the lender if the necessary conditions, X, Y, Z, all the conditions are met. One of those conditions includes all of the notice requirements and loss mitigation. The homeowner is going to argue that the lender was never permitted by the statute to commence the foreclosure action. So that's based on the statutory violation. The next one is breach of contract. The contract, which is the FHA note and mortgage, has been breached by the lender. The note and the mortgage each contain similar provisions that limit the lender's remedies and making them subject to HUD regulations, which include the notice requirements and the loss mitigation, so hence the breach. And then finally, the equitable principle. Here's where you connect all the dots to make your lack of good faith argument. So HUD policy is to intervene early and resolve the default quickly. And then the mortgagee benefits greatly from the FHA insurance protections. And if the mortgagee had followed early default servicing guidelines as they were required, we may not be here today. And that's laid out really beautifully in TEED, which we'll go over later. So Stephen, do you want to go in depth in these?
Yeah, and this is really where it gets muddy because there are cases all over the country talking about FHA. And just a quick plug for for those of you who have access to the National Consumer Law Center Loss Mitigation and Foreclosure Manual, at Pair 2, there's a long discussion of all of this. So I think it is truly important, as Trina pointed out, two things that she said that were really important is distinguishing between the sword and the shield idea, and also always keeping in mind this great idea that and reminding everyone that the mortgagee really benefits greatly from FHA protections. I think that's something to remind courts. Because when you get to it, you're in a judicial foreclosure state, so you're frequently going to be using this as a defense to foreclosure. Now, there are non-judicial states, or even there are other ways to claim an affirmative claim, a lawsuit, a counterclaim against the lender for a failure to follow the regulations. You're not going to do that, as the previous slide says, as a private right of action under the regulation or the statute, because that loses every time. But there is an argument, because these are incorporated in the contract, to try to use a breach of contract as a counterclaim. And that is still using it as a sword, but really what I will tell you is that the case law is very mixed on that issue. It's very dependent on the jurisdiction. But if you're going to do it, it generally is typically as a breach of the contract itself, the terms between the lender and the borrower. And so you want to always ground, if you're going to pursue affirmative claims, the sword, you need to ground it in the contract. And what I would say is the case law is mixed on that, and also I would reserve it for truly the important and really bad cases if you're going to go that way. So that's the sword. As a shield, that is where the law has been very positive for when borrowers are not afforded everything that's supposed to happen in the regulation. And what I will tell you about that is courts, as you can see from the theories of liability, really have gotten themselves to the defensive use as a shield in many different paths. Some courts focus on the regulation. Some courts think the contract is what the most important aspect is. Some courts just like using an equitable principle. It may have to do with who their contracts professor was at law school more than anything else. So what I would say is the real key is to when you're raising it defensively, to plead it well. Make sure in pleadings to talk about the FHA program, to be very specific, and also, and talk about what didn't happen. To use, not to use just cookie cutter pleadings that maybe say FHA in them or not. To be specific in pleading, because in many courts that has been an issue, and you may actually need to meet, and I'm not going to get into the nuts and bolts of this, but a higher failure of condition precedent pleading in some jurisdictions. The other thing that's very important to do is to do discovery and to really develop your cases, and to really show a clear path of why the FHA regulations were not met. And what I will tell you is, if you do those things, you plead it well, and you really develop your case, then a judge in defense is going to figure out what theory they like best. Now, you have Teed in New York. That may be the place the judges go, but there are cases from other jurisdictions. But again, and that's the defensive use of the regulations to stop foreclosure, and I think that's often where things are going to be. I think I answered then questions about who's got jurisdiction and liability. There's a question about different theories of liability, and again, what I will say to that is, if you're bringing an affirmative case, it's based on that state court contract and whatever other claims you may have related to that. If you have statutory claims in New York, that part I don't know. But what it's not going to be is a private right of action on the regulations. In the defensive part, I've already talked about. So I think that's my pitch on that. Let's throw it back to you, Trina.
Cool, thank you. Okay, so I'm just going to breeze through some typical arguments by lenders so that you're prepared for them when you see them. First one is homeowner's breach of claim, contract claim. It's just a private right of action claim in disguise. And fortunately, the courts can usually tell the difference. It's a pretty weak argument. You just want to be prepared for it. And you can look at Kirst's example to anticipate that. Next, we're exempt from the face-to-face meeting because there's no branch office within 200 miles. Well, this relies on a HUD website. Web office actually really means servicing office, and courts actually have consistently rejected reliance on the HUD website, which is a good thing. And this goes back to what we keep saying, primary and secondary sources of authority. Where the federal statute trumps statements on the HUD website, you want to be citing the statute. So,
and yeah. Trina, let me jump in here quickly on this, because it is my understanding, though I have not checked today, and one never knows what happens with
always
the website gone from the HUD website, which shows you the real importance in our argument to the courts about why this website should have never mattered. As someone who litigated this issue a lot, it was always, to me, patently clear that we should not be interpreting federal regulations through a website, and because things can disappear, and it's my understanding that that has disappeared. And to a question that was asked about servicing office, and the question is whether branch office means servicing office. That concept came from the website, which, like I said, has not been followed. Even when it was up, it was not followed. There's an important case in Ohio, the Isaacs decision, but the Matthews is good. It is very good too. And so I think what you should do, this comes back to the fundamentals, looking at the text of the regulation. And I don't think the text of the regulation, talking about office, which can include branch office, is all that ambiguous, and HUD should have never had that website up there in the first place. So I think that's just important to mention, and again, comes back to the idea of this great dichotomy that Trina set up with looking at the primary documents and then thinking about what provides input, but website should not be there. All right, thanks, Trina.
Thanks. Okay, so next, this This one, the homeowners can't breach contract because, or sorry, homeowners can't claim breach of contract because they caused the first breach. So here the lender's saying, how can we break a contract that the homeowner already broke? This argument hinges on whether the homeowner's breach is actually a material breach. Most courts get it once they really consider the potential absurdity of the lender's argument. I like the Sinclair language at the bottom where they say it's absurd to ignore the contract terms drafted to govern post-default conduct on the grounds that the mortgagors have defaulted. And so I think that's a great little quote right there. Next we have, homeowners have no damages. They've been living in the home for free. And I'm sure everyone out there, I can't hear you, but this is probably rankling you, as it does for me. It's just doubly offensive because it completely ignores the noncompliance issue, and it fails to recognize that the lender refuses to accept the monthly payments. So here it's critical to plead all compensatory damages, including punitive and emotional distress where available, and showing the court how the interest and the fees and the costs compound to preclude the loss mitigation. And when you're asking for relief, take every opportunity to tie the noncompliance back to the failure of the good faith. So ask to toll interest and restore the account back to the point where the failure occurred. And for a lot of people, that's going to be the third month when the face-to-face meeting was owed but never attempted. So Stephen, did you want to add anything on that before we go?
This is really important, and I think so. As not someone who practices in New York, I can't really talk about the when you're going to have a counterclaim and when you're going to have the ability to get damages versus affirmative defenses. But what I will tell you is, whether you're using this concept as a sword or shield, even if you're using it defensively, these issues will come up. Most of the cases, Mullins and Sinclair, are affirmative cases asking for a breach of contract and for affirmative damages. But believe me, the lender is going to throw these issues at you. And it's not only important to have the legal ammunition to knock down these arguments, and I think that the cases cited, and I'm especially also Sinclair versus Donovan is my case, and I am always delighted to see that language. I think also this comes back to the concept that Trina brought up, which is getting good cases, really in picking clients where, to the extent you can, and I'm not saying always, but the extent you can, where you can really show that they should have gotten some loss mitigation option before we even got here. Those are great cases, and really the ones that I think are good to focus on, especially in a developing area of the law, because that makes these arguments, that gives you great ammunition against these type of arguments. Because I will say, typical argument which is implied in these arguments that Trina set out, technical stuff, and we lenders did what we could, and so we didn't go and do this, but we shouldn't be required to do it. I think when you have these type of arguments to make back at them, and also you have developed a very good case, you have the ability to knock that down, because the constant cry that this is just technicalities are there and are going to be consistent no matter what kind of how developed the law is. I think that really drives at all of those, Trina.
Yep, great, thanks. Okay, so there's, as we said, there's not many cases in New York. It's still fairly open. Only a few cases. We have Teed, which is great, and we have Ricks, and we have Waters, where the court was kind of hung up on the private right of action argument. But Teed's a recent case, and it has excellent language and deserves its own slide. So,
if I can just add that Teed is one of our from Mark Wattenberg. It was a case out in Bath. Those of you that don't know, that's sort of south of Rochester. and he did a phenomenal job on that case. So just to put out, Mark Wattenberg was on the case.
Yeah.
Becky, it was hard to hear you. Can you repeat what you just said?
Oh, sure. I'm so sorry. So I just wanted to say that it was that case was Mark Wattenberg from Law New York out in Bath, New York, Steuben County. And just we were very, very pleased to get that case, and Mark did a great job on that case. So just putting that out there. Thanks.
Thanks. And the court totally understood. In addition to finding that the failure to make a reasonable effort for face-to-face was a failure of a condition precedent to foreclosure, there's also really great language where clearly connecting the legislative purpose of the National Housing Act and HUD's notice requirements. There's actually more language that I could even fit on the slide, which is why this is one of the pieces. This case is in the materials for today. The court says the importance of making reasonable efforts to arrange for a face-to-face meeting cannot be overstated. Goes on to say it's a fundamental understanding of the FHA program that when lower income individuals are confronted with even minor financial difficulties, they will often have trouble keeping up with their mortgage payments. And then the court concludes that regulations require mortgagees who benefit greatly from the protections afforded them through the issuance of FHA-backed mortgage loans to work with mortgagors to give them a chance to take reasonable steps necessary to save their homes. And it's wrapped up with a bow. It's a nice result. So in summary, first, it's critical that homeowners answer the summons and complaint. And housing counselors, you're the early line of defense, literally. So to preserve these defenses, it's critical to direct homeowners to legal services or legal clinics to get some help with the answer. Next, use potential FHA claims as leverage for modification whenever possible, especially in the settlement conference. And lastly, we have the arbitration clause, as Stephen keeps pointing out. So a good outcome will be very case specific. Choose cases where, as Stephen puts it, that the lender's noncompliance has truly deprived the homeowner of the chance to save the home. So that's all I have. Oh, that's not all I have. The HUD website is very difficult to search, so I just put some search hints on there, just at the end there. HUD Clips is a great keyword search for when you're looking to get all the publications. And the quote, loss mitigation mortgagee letters will return you a list of all the loss mitigation letters and not just all the mortgagee letters, which is years and years worth. So any questions or comments?
Before we, so we should do some questions. I think that would
absolutely.
be great. But before we do that, I want to mention a few things on kind of going back and making sure we get all of the main points out. I think the point about leverage is really good. I think, you know, what you're going to do for your client is going to be so fact specific, but I do think that having an understanding and a development of these cases to use as leverage to reach a deal that's good for your client is really important, and I think goes to both picking good cases but also understanding this to really see. And again, with the settlement conference regime or set up that I don't have, it's a different case, so it's hard for me to do that. But I do think the general principle applies, that this is really important. What's so great about taking FHA cases is that you have some law to really use and to make sure that your clients get a good deal. Because what's happened is that FHA loss mitigation options have improved, especially since 2013, when FHA finally fully fixed the FHA HAMP program. And again, FHA insured lenders do not fall under regular HAMP. They're special FHA HAMP. We're not going to get into those details, but you know, I think that makes it more important to take these cases because there are good outcomes, regardless, outside of what else you can get for your cases, depending on your legal claims. So I think that's really important to just to bear in mind. Again, I wanted to also repeat again that please be on the lookout for the new handbook. The idea is to consolidate a lot of the very disparate guidance on FHA issues. So 4000.1 again coming out in March of 2016, or sorry, it's already out, but going online in March of 2016 is going to cover both the issues that we talked about with respect to the face-to-face meeting, but also issues regarding some of the loss mitigation stuff that we have to deal with. So, for in terms of questions, I'm going to try to look at some of these. So one good, really important question is, if the mortgagor defaults and the regulations were complied with, and the loan is then brought current, do the regulations apply again? In other words, if the borrower has reached a loan modification and then defaults on that loan modification, does FHA have, do the lender have to follow the regulations? Question, and the answer to that is yes. Yes, they do. And why that is extremely important is that your clients are often going to have multiple loan modifications. And they may default on previous loan modifications in part because the previous regime of FHA-insured mortgages, of FHA-insured loss mitigation was not very good at all and did not provide a lot of payment relief, contrary to what we have in place now. And this is specifically important because you can definitely bet that lenders in these cases will bring up previous loss mitigation and loan modifications as a good reason why you should not win on your cases. So not only is it important to recognize that, yes, they do need to follow the rules if the is brought current and then they default again, but also to understand that context in order to explain that, hey, look, that this may have been done under a previous regime where, heck, it could have even increased the payment or was not, where there were not the same affordability guidelines. So I think that context is really important. So then another question has to do with whether the this whole 12-month, there's a question about a FHA-insured lender would not modify the loan if it was more than 12 months behind. That's a good question and probably has to do with that old regime I'm talking about. Under the former version of FHA HAMP, there were some really screwy rules with a partial claim. A partial claim is a component in some loss mitigation tools for HUD where there's a loan to HUD. I'm not going to get into the details of that except to say that former past 12 months behind, you should be declined for a loan modification. The new FHA HAMP regime that came online in 2012 and then was improved and fixed in 2013 and 2014 eliminated that, so that should no longer be an issue. But it's important to recognize that that could still be out there because not all lenders are totally up to date on their loss mitigation waterfall.
But to clarify, that is no grounds for denial of the modification.
Right, and also to clarify, look, I'm glad you said it that way too. There's also this point of, again, remember, in defending FHA-insured cases, think first about what is in the regulation. And a lot of that stuff is not in the regulations. Now, again, as I've told you, whether a case is the strength of a borrower's case can, again, depend on whether they should have gotten loss mitigation or not. But I think it is important to clearly define things that are legal obligations that we need to look at in defending the foreclosure case, and then those rules that apply in the loan modification process. what else do we have here?
Well,
Is
Frida,
there
I have a
regulation or sorry, go ahead.
Sorry, I have a question for you. Is it advisable to use the HUD handbooks as a sword?
Well, so you're not. This is a good question. So if you're going to bring an affirmative case outside of, based on the contract, outside of any other statutory claims you may have, you really got to ground yourself in the language of the contract as incorporates the regulations. Now, so those are going to be your main, in my opinion, those are your main. Compliance depends on, or can be review. You know, you look at whether there's compliance based on, again, the handbooks inform, give kind of some of the ground rules about what HUD at least thinks a face-to-face meeting should be, and some of the other things should be. So they can come into play, but that's not what you're not enforcing the handbooks in those affirmative sword type cases. And this other thing I will say, at least in my opinion, is that I think those are the best cases for that are really where there's some really bad facts. But that's another really good question. The other question is there a regulation requiring an acceleration letter to be sent before X amount of days? So one regulation that was not included in the slides, but I think is also important, is at 24203.602, which is a notice regulation. I don't know how often. I mean, that one in Ohio gets complied with pretty. They usually can send that letter in time, but not always. So I think it's definitely worth considering in your checkbox. And I will repeat that. It's at 24 CFR 203.602. So that's there, and you can look at it, and it just depends. It is not the same. That's one regulation that's different than the 604 regulation with the face-to-face meeting. Let's see what other questions we have. I think those are the main questions. Is any, and we're also getting short of time, so please feel free to type in other questions. Oh, here we go, a comment. Oh yeah, okay. I think this is a very important comment, and I said it, and I will repeat it because I do think it's important. The comment has to do with bad summary judgment decisions that go the wrong way because instead of having admissible evidence of lender noncompliance, there may be attorney affirmations, or just, I've seen in Ohio with a borrower, some attorneys just in their briefs stating that there's no compliance with FHA regulations. It is really important to have an eye to what is admissible evidence, and making sure that you have affidavits or requests for admission or anything else to really ground your argument. And it doesn't have to be fancy, it doesn't have to be complicated, but I do think you want to think about the evidentiary basis of these claims, because as lenders get more sophisticated with these, and lenders' attorneys get more sophisticated with these issues, the more you're going to see pushback, and I think the better pleadings and the responses to summary judgment need to be. So I will. We have not a whole lot of time left. I want to give my contact information again. It's on the slideshow, I believe, but I really encourage people, if you want to talk through these cases, I am always more than happy to do so. I think some of you on the call, I've talked to a lot of you who are on the call, and I'm always willing to do it. What I will tell you is it is much more enjoyable to talk about other people's cases than having to deal with my own, because all I have to do is give some advice, or at least what I call advice, and I don't actually have to do it. So it's always more pleasant to do that, and I will leave that open to all of you. Trina, anything you'd like to say?
No, that's it. Thank you so much.
So that's great. Steve and Trina, I cannot tell you enough how fantastic this presentation was. We had, I think, 93 attendees at one point out of the 100 or so that we've got allocated. Clearly important information. Steve, just to simply nod in Steve's direction that he has absolutely supported those of us in the western and more central region of the state. We have leaned on him for some advice on things, and he has been incredibly gracious and more than willing to give whatever it is that he has in his support. So thank you, Steve. Trina, you did an amazing job. Thank you so much today. And stay tuned for April when we have Steve come back, and we have essentially part 2, I guess, of this. So thank you, everybody, and have a good day.
Thanks, everyone.
Oh, one more thing. I'm so sorry. So make sure that those of you who are looking for the CLE credits or the attendance certificates from Michelle, the CLE credit, I'm trying to find it again. Where did it go? Is T as in Tom, 315, H as in house. So just send that along to Michelle, and she will get you your certificates, both attendance and CLE certificates. So again, wonderful job, everybody, and thank you so much. Have a great day.
Thanks, everyone.
Bye.